Good afternoon from New York. I'm Chris Hayes. Thank you for joining us for a special 2-hour, 4 p.m. edition of All In. It's a little under an hour ago. The Supreme Court rejected a proposal from Special Counsel Jack Smith to accelerate a decision on Donald Trump's claim of presidential immunity in his federal election criminal interference case. Now, the one-sentence reply, the order from the Supreme Court reads, quote, "The petition for writ of certiorari before judgment is denied." In other words, we're not going to speed this through. We're not touching it before it goes through the normal appeals process, which is the appellate circuit court in D.C. That outcome is exactly what Special Counsel Smith was hoping to avoid, because the appeals process could give Donald Trump ample time to further delay this case, which is, of course, supposed to go to trial just a few months from now, in the first week of March. Trump may now try to delay the start of the trial until the calendar begins to encroach on next November's general election, at which point, if he's the nominee, the ex-president can then ask the court to put the case on pause until the presidential contest is decided. And, of course, should Trump win that election, the case would go away entirely, which is, to be clear, and what we all understand, including the people on the Supreme Court, exactly what he wants. Although, I have to say, it is still unknown if Trump will be allowed to meaningfully delay this trial. And we should note, while the court granting what's called cert before judgment, this sort of leapfrogging that Smith wanted to do, is historically very, very rare, under the Roberts Supreme Court, it's been weirdly common. I mean, Roberts Supreme Court has done this 19 times since 2019 alone, according to analysis from Supreme Court expert Steve Vladeck, who has built a life's work studying this exact procedural wrinkle. On everything from affirmative action to a whole bunch of COVID restriction cases, to student debt relief. They just reached in and said, no, we don't need to hear from the appellate court. We want it now. We want it now. Give it to us. But when it comes to the question of whether the man who tried to end American democracy should face trial before voters decide if they want to elect him to finish what he started, it appears, for now, the MAGA Supreme Court just doesn't appear to be in much of a rush. Melissa Murray is a professor at the New York University School of Law. Harry Litman is a former Deputy Assistant Attorney General for the Department of Justice. Marcus Childress served as investigator for the January 6th committee, and they join me now. So it's great to have all three of you. I got the news, and my first thought was like, how should I feel about this? So, of course, I texted Kate. But I'll start with you, Melissa. How should I feel? How do you feel?
Well, I'm a little surprised. I mean, as you say, it's not uncommon for the Roberts Court to grant cert before judgment. They did so with the affirmative action case last year. The First Circuit had proceeded and decided the Harvard case, but the Fourth Circuit was still waiting to decide the UNC case, but they took it up on cert anyway. They also did the same thing with Biden versus Nebraska, the student loan case. And there's a broader historical precedent for this as well. In United States versus Nixon, the Supreme Court granted cert before judgment in order to determine whether Richard Nixon had to comply with the request to turn over certain tapes because there was a pending criminal trial of the Watergate burglars. Here, the same kind of equities are in balance. Like, it's not simply just a criminal trial that's going on here, but the fact of an election and whether or not the American people deserve to know whether someone that they're voting for is able to stand trial on criminal charges. So it seems like there are really important issues at stake here, but the court kind of slow walked this a little bit.
So, Harry, we know, so the normal procedure here is that there's a district court judgment by Judge Tanya Chutkan, who I thought wrote a very strong and persuasive judgment that says, look, no, you can't assert presidential immunity for actions that were A, criminal, and B, had nothing to do with your official office. You were working as a candidate to overthrow the constitutional republic. It wasn't like you were overseeing some rulemaking in the Department of Labor, right? So that's persuasive, I think. It then gets appealed to the appellate court, D.C. Circuit. Now, they have moved quite quickly. So I guess my question to you is, Smith wanted to move even faster than that, but now it's going to go through that appeals process. So what's your thinking about what this signals for timing here?
For timing, I think it probably means maybe a 60-day or so delay. But I think you've just cited, Chris, the pivotal fact, because that happened after Smith petitioned for judgment for certiorari before judgment. And by the time it came up to the court, there was the prospect that the D.C. Circuit would be moving very quickly. We already know they're going to have oral argument on this January 9th, will probably issue a decision very quickly thereafter. And I think the court, it decided this, whether or not to do it very quickly. I think it's aware of the importance and the need for expedition, but it said to itself, you know, we could have a fuller treatment by the D.C. Circuit in just a few weeks. I've written my share of cert memos as a clerk, and that's something they really care about, having it full from the D.C. Circuit. And you mentioned the MAGA court, but this was unanimous without dissents. So I think the 9, who in general are eager to avoid polarized decisions and black eyes, coalesced around the idea, let's just wait a few weeks to have the benefit of the D.C. Circuit opinion. And as for the point you make about ultimate timing, even if it delays things, even a couple months, we're nevertheless not on the threshold of November. I think they are very aware themselves of the calendar. Witness that they jumped on this when asked. And so there, I think the effect is real, but not fatal.
Yeah, so that's an important point. Just sometimes cert petitions will come with dissents authored by any of the justices who can write separately and say, look, I think we should have taken this case. In this instance, we don't have that. We don't know. There's no public. Cert votes are not made public, and you only need 4 to grant cert. You don't need a majority, but so we don't know for sure. But we know that there's an absence of anyone saying, "Hey guys, we should have taken this." Now, there's an interesting procedural move, Marcus, that the Colorado State Supreme Court used, which I thought was interesting, and Steve Vladeck pointed this out. They basically issued, he says, for those that are worried about Trump slow walking an appeal to SCOTUS if the D.C. Circuit rules against him on immunity, which I think we all anticipate. The Court of Appeals can preempt that by doing what the Colorado Supreme Court did, a stay that expires, basically a kind of exploding stay, right? A ticking time bomb, a stay that expires unless Trump seeks certiorari within, say, 14 days. So there are some ways the D.C. Circuit itself, Marcus, can also attend to the urgency of speed here.
Yeah, I agree. And if anyone's aware of how the Trump team and folks associated with him like to slow walk these investigations, it's me from the committee. But I want to point to the I want to point to the 11th Circuit. I mean, if we look at that as kind of an indication of how fast these circuit court opinions can occur, you have to look no further than Mark Meadows just a few weeks ago, right? It's a different issue. It was a removal issue. But the court heard argument on December 15th, I believe, and within December 18th, we had an opinion. And so that's just 2 or 3 days. And so I think it is smart by the prosecutors and the special counsel here to seek expedited review at the D.C. Circuit while also seeking review at the Supreme Court, thinking that this might be a real possibility that the Supreme Court wouldn't grant cert here. And so now we have a situation where argument will be heard on January 9th. And as the co-panels have just said, right, that doesn't push back the trial date too far. I mean, let's say we push it back 90 days, as was just suggested. A May trial date is still in a good spot for the special counsel's office.
Yeah, and I mean, again, all of this sort of circles, Melissa, this weird combination of the sort of bizarre kind of realpolitik of a kind of would-be authoritarian who wants to get office so he can stay out of jail and dismiss the cases against him and wants to forestall any judgment before a jury of his peers, and the rules of federal procedure, basically. And then sort of the cherry on top is the rules of federal procedure kind of are what they are until the court decides they want to move things. Like, this is what's so interesting to me. When you go back and you look at these cert grants before judgment, there's all these COVID cases. There's that period of time where the Supreme Court was just like, every COVID, every local COVID restriction, they were just like hoovering up to the court. Time and time again, they could not wait to get in there to tell basically local governments they couldn't shut things down for COVID.
Yeah, I agree.
It's a really great point. I do want to push back a little bit. I know Harry has made clear that this might result in maybe a 60-day or 90-day delay, but a delay is a delay, and there wasn't that much cushion in this trial date to begin with. I mean, the November election is coming. There are going to be delays inevitably because this is someone who is determined to delay this, and whether it's because he's on the campaign trail or he's got a convention or whatnot, there will be other delays. So this is a tactical victory for Donald Trump, even if it's not necessarily an irrational decision by the Supreme Court. But Chris, you make an excellent point. where this court saw an opportunity to move jurisprudence in a particular direction on a range of issues of incredible salience to the American public, they did not flinch at the prospect of granting cert before judgment. And we saw it time and time again. They were not interested in a fulsome exposition of the issues in the lower federal courts. They reached in and they grabbed them and they decided them. And they could have done that here, too. And I agree, this will be more fully briefed after going through the D.C. Circuit. The D.C. Circuit is going to do this with considerable expedition, but it is still a delay, and that makes it a victory.
Well, yeah, and that, Harry, is that's what's so strange about this. And I think I think you're both right? Like, it's a delay. There's also enough time. There's cushion built in. But it's the first delay. And what's so bizarre and surreal about this setting, Harry, is that it is zero sum in that, like, literally the number of minutes are a finite amount and they're on the board. And the job of Trump's lawyers is just to eat as many of those. So every day that they wake up and they gobble some of those minutes off the board and days off the board, like, that's a win. And they're going to have a whole bunch of bites at it, right? There's going to be a whole bunch of ways between now and that first day of an actual trial and then a verdict that they are going to keep taking those bites.
All true except maybe the last point. Yeah, it's absolutely right. Since Chutkan is held, she was urged by Smith to say, let's go forward with the pretrial stuff, just hold the trial. She said, no, I don't have jurisdiction. So a day here equals a day of delay. I agree, and I agree with Melissa. It's a not insubstantial delay. But this was always, remember, Chris, from the time this motion dropped, we saw this as his big opportunity for delay because it gave him the automatic stay. So he'll try other stratagems for sure, but there's reason to believe that Chutkan and the D.C. Circuit, if it comes to it, are pretty much onto them. So I see this as his big shot for delay. I don't know about those other bites at the apple. He'll try them, but I don't think she'll receive them very willingly.